Thank you, Mr. Hustings. And I will just give the floor to, we'll reserve the comments for afterwards, after the first round of speeches. And I will give the floor to Peter Fleischer from Google. And Peter.
Great, thank you very much. It's always hard to take the floor after the Pope of Privacy has spoken. It's particularly hard when you're between the Pope and the politician, but that seems to be my role these days. So. I thought I would talk a little bit about global privacy standards as we see it from Google. You know, I have two passions in life. One is privacy and the other is technology. And I think those two come together in the most fascinating way in the way Google is in the middle of this debate and the kinds of issues that we're confronting. And I'd just like to remind people of a couple basic facts. You know, 3/4 of the countries in the world do not have any privacy regime whatsoever in place. We talk a lot about Europe and how we can do better, and I've got a few thoughts on that as well. But really, they're a footnote in the broader picture of the fact that most of the world just doesn't have anything in place yet. You know, the architecture of the internet is such that data is flowing around the world all the time in ways that were simply unimaginable back in, let's just take 1980 as an example, when the OECD principles were first being promulgated. I mean, you remember the motivation for the OECD principles was transborder data flows. And if you think about it, the amount of data that is flowing across borders today, a quarter century later, is millions of times greater than it was then. I mean, if that was already a source of concerns amongst policymakers for the free flow of data across borders then, think how much more urgent it is today. There's every reason to believe that based on technological developments, the total amount of data that will flow across borders a quarter century hence will be millions of times greater than it is today. That's the magic of logarithmic growth that we see on the internet. I would be really clear, we're talking about raising standards where they don't exist at all. We're certainly not talking about lowering standards in Europe or other places where they do exist. So why would Google care about this? Well, we have a couple different angles on this. One of them is, you know, consumers need to trust the internet. They need to trust not just Google, they need to trust the internet more broadly. And to the extent that we can help create a framework for protecting consumers' data online, we will help to contribute to their greater confidence and use and adoption of the internet as an amazing medium. The second thing is that as a business, we need to comply with a set of rules. And like all businesses operating across many different borders, we are sometimes confronted with the problem of conflicts or different standards or different interpretations. So harmonization, at least in the realm of the internet, is of course a helpful thing to business, and in many ways, in fact, it's even necessary. A lot of the things that we do can be run to one internet architecture and that cannot be designed to stop and change at borders. The fundamental architecture of the internet wasn't designed around borders. I think we all know that. But if you think about data flows, it means that many of the things have to be done to a standard. Now, people sometimes say, oh, well, that's easy, just do it to the highest common denominator. And while that's a nice slogan, in practice, it's not always so easy to know what that is, right? So it's one of the things that we need to focus on. Every time you use your credit card, your data may be flowing across 6 or 7 countries. A recent study showed that. And you know, a regime of privacy protection, and this may be picking up on one of the things that Peter mentioned, is one of the areas that we can think about, in Europe in particular, is what are the elements of the regime that we have in place that might need to be rethought for the future? Clearly, the principles have proven their worth since 1995 and have been adopted and respected by many people around the world. Nonetheless, it is, at least in part, an export control regime, right? On a model that the export of data outside of one region, namely Europe, to another region would be subject to various regulatory restrictions and adequacy findings. And all of that might have made sense before the internet, but that just doesn't make sense in the age of the internet when these exports happen every time someone clicks a mouse. So we do need to rethink that. What I'd recommend is that we focus very hard on distinguishing between privacy principles that are universal and valid and don't change over time, and the administrative application of those principles that will inevitably vary from country to country and that will vary depending on legal, regulatory, and cultural traditions. And that's one of the things that I think people need to keep in mind. I think it's sometimes been confused, and I'll be slightly critical on simply one point, with regard to European findings relating to adequacy. I think there's been a confusion, a conflation, if you will, between the administrative application of principles and the principles themselves. I think we need to rethink adequacy as a concept for data exports going forward if it's not to become obsolete. Now, in terms of development, I think we all know that technology itself develops according to a different timeline than law and policy making develops. And I think in the era of the internet and data protection, we've seen this discrepancy of developments particularly dramatically. The internet was a phenomenon that was already dawning when the directive was first adopted in '95, but people couldn't really have thought about the implications for data flows. Here we are, I don't know how many years later, and we're still talking about this. So I actually believe that there needs to be a sense of urgency to think through some of these things so that they don't become simply obsolete. Now, what does it mean for the 3/4 of the countries in the world that don't have these regimes in place? Well, what should the model be? I think the OECD principles have been widely adopted around the world by many different countries. But one thing I know absolutely is that certain administrative applications of those principles, as we've seen them in, let's take France as an example, because it probably had the most influence on the European model that we have today. French regulatory proceedings of the 70s are most certainly not going to be appropriate for the majority of countries around the world. And so we need to be able to separate those two principles for this all to work. Now, people will say, well, Google, are you just trying to raise or lower standards for yourselves? Well, of course not. I mean, we will apply the standards that we think are in the benefit of our users. We'll try to apply the famous highest common denominator and figure out what that is to the extent that we can. There'll be variations from time to time. But we also know that we work in an industry where we are constantly inventing new things that present questions that people haven't addressed before. So we'll simply have to get used to the fact that we're in a world where people are trying to understand how do we apply traditional privacy principles to a new service, to a new way of finding and interacting with information. I mean, if your fundamental mission in life as a business is to help people find and organize information, well, privacy is going to be pretty central to that mission. So the questions that we're debating internally and that we're talking about with stakeholders, if anything, will become only more important in the years ahead. Let me cite just a couple examples from Google's perspective that you may have heard about or wondered about. We have a service in the US called Street View. You can type in an address in Google Maps and get a picture of the building taken from the street. Currently, it only includes 7 US cities. It's only in the US right now. And it's true that when those pictures are taken, sometimes coincidentally, people are walking down the sidewalk at that exact moment. And in the US, there's no doubt that that's legal. There's a long tradition in the US that a public space means exactly that. It's a public space. You don't have the same expectation of privacy. And yet, there's still been a question about whether that's right ethically in the US, or more broadly, whether that's right legally in other countries, such as Canada. Many of us were in Canada for the Commissioners' Conference a few days ago. Well, I announced it in Canada. When the time comes to launch in Canada, we'll do it differently. We'll try to have a version of Street View that doesn't have identifiable faces and doesn't have identifiable license plates on cars. Now, will some people still be identifiable to someone? Like, I know that my wife wears a red coat, and even though you can't see her face, she said that's a red coat, so I think that's my wife. Yeah, of course. But that can't possibly be the standard according to which a web service is going to have to operate its process in a kind of pragmatic universe. We'll be debating these questions for quite some time to come. We also announced that we would anonymize our server logs after 18 months. We were the first in the industry to do that, and subsequently, the other leading players followed our lead. I think that's wonderful for privacy. It's a huge step forward compared to what it was before. Some people will, of course, say, especially people who are particularly focused on data protection, 18 months is great, shorter would be better. And that's fine. We can continue to have that discussion. What's important from our perspective is to say, but look, it's a balance between sometimes conflicting factors. Yes, shorter is better in privacy terms, but we also have to have data for other purposes, to maintain the security of the systems, to be able to investigate and defend against hacks. Remember, we make our money when people advertise and users click on advertisers on our sites. We need to have records of that. Like all businesses, you have to have records that justify what you invoice your business partners for. That's what we use it for. So that's a series of issues that a number of people have talked about in the data protection community, and those conversations can continue. Ours is a balance. I think we struck the right balance. Other people might strike the balance differently. That's always the case in the real world. People balance factors differently. But I have no time for the extremist community that says that logs shouldn't be retained for 1 second after someone conducts a search. That's not an analysis, that's ideology, because what it says is, I care about privacy, but I disregard all other factors. I don't care about security. I don't care about preventing fraud on the internet. I don't care about the ability to improve search engines and algorithms and all the other, what I think are quite legitimate interests of people. So those are examples of debates that will continue. We also recently announced that we'd reduce their cookie lifetime to 2 years. If you go into your browser today and look at the cookies that are placed on your machines by lots of companies, you'll see that long-lived cookies, 10, 20, 30 years, have become quite common. I don't think that there's anything inherently wrong with long-lived cookies, to be quite clear, as long as there's notice to consumers and consumers can control them via their browsers. Nonetheless, we heard the concerns from many people in the privacy community, and we instituted the new policy and reduced it to 2 years. It's quite an improvement compared to the prior expiration date of Google cookies, which was 2038. Granted, that's longer than most people's PCs that they would reside on, and we acknowledge that. So I think that's another area of improvements. I expect our improvements to continue for quite some time. I just cite 1 or 2 little examples that I think are kind of interesting. You know, notice and transparency to consumers is probably the most important thing we can do as a company, to explain how does this all work? What information are we collecting? How do we use it? What are the user's choices? But figuring out how you provide that notice in the context of internet services is actually rather complicated. Most of us use privacy policies. These are written documents. Sometimes they're legalistic, sometimes they're not. But the reality is a lot of consumers simply don't read them. So despite all the work that we put into them, a lot of people don't use them, don't like them, and you can't force people to. So we're experimenting with some different models, and we've put out 2 privacy videos. We had one of our support engineers at Google be the speaker for a video to explain some really basic but fundamental concepts, like what's a server log, what's an IP address, what do you capture when someone does a search, how do you use it, how long do you keep it, why do you keep it, and when do you get rid of it? Those are the kinds of things that we have said for a long time in our privacy policies, but those are written documents, and people don't necessarily read written privacy policies. We've had an amazing reaction to our privacy videos with no advertisement, no promotion whatsoever. Last I checked, we were at very close to 60,000 hits on our first privacy video on a geeky topic like IP address and search, right? I think that's pretty good, and I think that's very heartening for the future as an initiative. So I expect we'll try more in the video format, and it might be interesting if other people do that as well. And speaking of the video format, to the extent that we can upload today's event or parts of today's event up to YouTube, it will allow a much broader circle of people to participate and be engaged in the public policy debate that we're talking about here today. And I think that's also a good thing. Going forward, data retention, who knows? I mean, who knows how that's all supposed to work? And I don't mean to be flip. I'm actually trying to figure it out because I'm one of the people it's directed at, right? So what exactly does it apply to in jurisdictional terms? Which services at Google would it apply to? Does it apply to a service provider, or in what ways established outside of the EU? What happens when every country in the EU picks a different time period? What time period do you retain things for if you can only have one time period? The longest? The shortest? An average, where you just pick whichever one you think is best, whatever that means? I mean, those are like very basic questions, and I'm not being political. I'm talking about it from a very practical point of view, quite apart from what I think of the directive, or whether it will be useful or not useful in security terms, just what do we do with it? And I think the next stage in the debate is going to be a practical debate about how do we understand it and how do we interpret it. We will have one time period. So, some countries in Europe pick 6 months and some 24 months as permitted under the directive. We'll have one, and I don't know what that one will be yet. But I mean, just pointing that out is a practical problem in all of this. And finally, just so that you don't think that this is exclusively a European debate, which it most certainly is not, we continue to work in the US for federal consumer privacy legislation. The US is a federal system, as we all know. Take one example, security breach legislation. At my last count, I believe there are 39 different US states that have each 39 slightly different security breach legislations in place. As a company that does business across the US, you have to comply with them all. And so the problems of non-harmonization are not unique to Europe. That is very much a problem in the US as well. You would think the time would be ripe for federal preemption, in other words, having one US federal standard on a security breach notification. And the discussions are also arising to policy sense in Europe on the topic as well. One just very practical piece of learning from the US, this is one of those rare cases where the US has more experience in privacy legislation than Europe in a field, security breach legislation. Let's be careful not to set the standard so that people become inundated with notices that create no harm and on which they can do nothing. If we cry wolf too often as an industry, if people get another letter in their mailbox every week or every month, they'll just throw them out, they don't know what to do with it, and it will ultimately undermine the cause that we all do care about, which is providing meaningful notice to people when something has gone wrong so that they can take steps to A, be aware of it, and B, to rectify it. Thank you.